Good morning. Welcome to our Spring Construction and Development Legal Briefing. Thank you all for taking the time to attend today. This is the first in a series of regular talks, which we hope you'll find both interesting and informative. I'm Rebecca Williams and I'm co-head of WFW's London Dispute Resolution Department. I have over 20 years of experience advising on a whole range of construction and engineering projects, and I'm hosting today's webinar. In terms of format, today's webinar consists of 4 different presentations and each is a bite-sized 12 minutes long, with a short Q&A session at the conclusion of all of the presentations. So I'll be moderating that, and if you could just direct any questions via the Q&A function that I mentioned, that would be great. Just to reassure you, your questions will not be displayed to the audience, so please don't be shy. We, as I said before, would be delighted to answer any questions, and we like these sessions to be as interactive as possible. In terms of today's lineup, first up, we have a roundup of the latest need to know developments in relation to adjudication enforcement, which will be presented by Ryland Ash. Ryland is a leading individual in the world of construction law. He qualified as a barrister in 2003 and then worked for several years as an in-house lawyer to Mitsubishi Heavy Industries in Taiwan. He returned to the UK in 2008, and prior to joining WFW's team in November 2020, Ryland was managing partner of a specialist construction city law firm. Over the years, Ryland has regularly provided training for main contractors, the RICS, CIRB, as well as banks and local authorities. Second up, we have WFW Senior Associate Alex Creswick, who will present on the rather fraught issue of hybrid contracts, when they arise and how to ensure your contract is compliant with the Construction Act. This has been an area of fertile ground for dispute, so that will be an interesting one. Alex is dual qualified and is admitted to practice in England and Wales and New York State. He has wide-ranging experience of all types of construction and engineering disputes and all the major forms of contract, but has a particular expertise in renewable energy projects. Alex was a member of the WFW team that was awarded Legal Week's Construction and Engineering Litigation Team of the Year in 2019 and shortlisted for Legal Business's Commercial Litigation Team of the Year in 2020. Next, Daniel Miles of Aquila Forensics will be joining us to look at who pays when works are disrupted, 7 key points to consider. Daniel is a director and co-founder of Aquila Forensics. He is an experienced chartered quantity surveyor and testifying expert witness with over 15 years of experience working on high-value, complex disputes and has given evidence on multiple occasions. He specializes in the provision of quantum advice and has had numerous appointments as both expert witness and claims advisor in disputes relating to construction, professional negligence claims, and quantification of damages under all the major standard forms. Last, but certainly not least, Barry Hembling will present on how not to carry out a construction project. Barry is a construction specialist with over 20 years in-house and private practice experience of acting on both domestic and international projects. He provides both contentious and non-contentious legal support throughout a project's life cycle, from initial contract advice, support on live projects, and of course, dispute resolution. Barry was formerly in-house legal advisor at one of the UK's largest contractors and now helps clients by offering commercial solutions that crucially minimize project risks and help clients meet both budgets and completion dates. So without further ado, I shall hand over to Ryland Ash.
Good morning, everybody, and thank you very much to Rebecca for that kind introduction. I barely recognised myself. The subject of my talk today is going to be in relation to updates on adjudication enforcement. Now, this is a very broad subject, so I will do my best to get through the subject in the time that we have. So the starting point for this subject is the issue of the presumption that an adjudicator's award will be enforced. So parties that go to adjudication will rely upon the fact that it is enshrined in the Housing Grants Construction and Regeneration Act that the decision of the adjudicator is binding until the dispute is finally determined by legal proceedings, by arbitration, or by agreement. So there's a presumption in favour of the winning party when they're holding in their hand an adjudicator's decision that they want to enforce. Now, in the early days of adjudication, and I'm pleased to say that my video is making me look younger today, I recall that there was really only one ground to challenge an adjudicator's decision, and that was a breach of natural justice. Now, the trouble was back then, nobody really knew what the parameters of a breach of natural justice were, and so that's developed over the years. We've now got three distinct areas of challenge, the first being fraud. Now, this principle has actually only been developed in finer detail, I would say, in 2019, following the case of BBS and Bester. And that case, incidentally, is a landmark case which was run by my esteemed colleagues here at WFW. And they were successful in arguing that an adjudicator's decision should not be enforced where it was procured by fraud, even where those arguments weren't raised in the adjudication itself. So that goes back to the age-old maxim in English law that fraud unravels all. The second ground is breach of natural justice, and I'll come back to that when I give some examples in the cases we'll run through over the last 12 months. And the last is where an adjudicator acts outside of their jurisdiction. So the normal procedure to enforce an adjudicator's decision is by way of a Part 8 application for summary judgment. And pre-COVID, this process would be quite quick. It would normally be between 6 to 8 weeks. And the TCC, the Technology and Construction Court, has historically tried to get these summary judgments through as quickly as possible to ensure that parties get paid. The first case I'd like to raise your attention to is this Millcrest Developments and Waters case from 2020. The reason why this is interesting is because it was the first case that I could see was reported around the time that the pandemic broke. And in this case, the defending party said that they couldn't run the adjudication because they couldn't get access to their solicitor who was isolating, and they couldn't get access to documents due to the coronavirus, broadly speaking. And the court said, no, we're not having any of that. That's not a valid excuse. And that should not stop the adjudication. And therefore, in that case, the decision was enforced. So that reinforces this presumption in favour of enforcing decisions, even during a worldwide pandemic. The next case to look at is Quadro Services. This relates to a subcontract for university buildings works, which obviously led to a dispute in relation to the contract, including a dispute over repudiatory breach. And in this case, when it got to the courts in relation to enforcement of the adjudicator's decision, the question before the court was whether you could stay the decision of the adjudicator on the basis that there was an impact on the business of COVID, first of all, and secondly, as a consequence of this decision, a loss of a serious contract, a substantial contract for that business. So the courts considered whether or not you could stay the decision in those circumstances. And again, the court said, I'm afraid that's not enough. The impact of COVID wouldn't have impacted your financial standing in any event. The onus was on the defendant to prove that the claimant would be impecunious or in a position where they couldn't repay money. And therefore, ultimately, the court decided to enforce the decision. So it's business as usual, no excuses, pay the money now and argue later. And that really is the underpinning principle that the UK courts have developed and have stood by, notwithstanding the pandemic. The next case we're going to look at is Global Switch Estates. This is a 2020 decision, and in this case, the adjudicator's decision was not enforceable. So if you're in the audience or you know somebody who has a decision and they're wondering whether it's enforceable, that's obviously a question that you could ask us in due course. But this is a good case to demonstrate where a decision will not be enforced. And this was a case about a data center which was built by Sudlows under a JCT design and build contract. And as is becoming more common, there were a series of adjudications. There were some smash and grab adjudications where parties were seeking everything that was applied for in an application for payment by virtue of the lack of payment notices in response. And then there was a true value adjudication subsequently to that. And in framing the true value adjudication, the referring party tried to limit what the responding party could rely upon in its defence. And that was something that the adjudicator, it subsequently turned out wrongly, subscribed to. The adjudicator accepted that the responding party was limited in what they could raise by way of defence. And so when it got to enforcement, the court said, Justice O'Farrell said, you can't limit the defences that a party can rely upon. And this goes back to earlier case law from many years before, Justice Aikenhead and Ivasco and Cantillon, for example, where he said you can raise any arguable defence, particularly where, this is a claim for payment. If there's a claim for payment made against you, you're entitled to bring any defence. And the fact that defences were limited in this case meant that the decision of the adjudicator was not enforceable. The third case is Montecas Construction and Paolo Castelli. In this case, falling back to form, the courts decided that the decision was enforceable and summary judgment was given. Now, this is an interesting case because it's in an article that I've written with a colleague at WFW, we've described this as sort of the first post-Brexit adjudication enforcement case. And it's interesting because the courts decided that it didn't matter that the parties had agreed that the courts of Paris in France had exclusive jurisdiction and that Italian law applied to the contract. The English court said, well, that may be very well, but the fact is that this dispute has arisen in England. There's an interim entitlement to enforce this decision, and that's exactly what they did. So they were flexing their muscles, it seems to me, and they did so by saying that there was no contradiction with the Hague Convention. And the final case I'd like to refer to is Aquila Leisure versus Benchmark Leisure. And I've raised this case because it's about a water park, and it gives me fond memories of warm climes and holidays, which I'm sure will brighten all of our days and hopefully return soon. And in this case, this is where this is a good example of where the courts can sometimes now sever an adjudicator's decision. So they can enforce part of the decision and dismiss the remainder. And the other issue in this case was whether or not after the adjudicator's decision was handed down, the parties had compromised that decision by way of an agreement. But that agreement stated without prejudice save as to contract, which is a slightly awkward phrase to essentially say it was subject to contract. And the courts decided that the parties, by using that phrase, hadn't intended to compromise the adjudicator's decision, and therefore it was enforceable. However, there was one last point. The adjudicator had given one of the parties, the winning party, their legal costs. He'd made an award in relation to legal costs. Now, I myself have been successful in the past in arguing that a party is entitled to legal costs, following what was essentially a grey area under the Late Payment of Commercial Debts Act 1998. However, in 2017, in the case of Enviroflow and Redhill, the courts decided that actually you can't recover your legal costs in adjudication. And bearing this in mind, what the TCC did is they said that part of the decision is unenforceable and essentially severed that from the remainder and thereby gave enforcement of that part of the decision that was enforceable. So in summary, we can see that whilst case law has developed certain areas by which a party can challenge an adjudication decision, all in all, the courts really do try and bend over backwards to ensure that the principle of pay now and argue later will survive. But if you're in a position where you have a decision or a decision is developing and you wonder what to do about it, we can certainly give you specialist advice in relation to that. So that concludes my presentation for today. I hope it's been useful, and by all means use the question facility at the end of today's presentation to ask any questions. Thank you very much. I'm now going to pass over to Alex Creswick to talk about hybrid contracts.
Thank you very much, Ryland. So the scope, talking about hybrid construction contracts, the scope of the Construction Act and hybrid contracts is a nuanced and wide subject that can easily and does take up whole chapters of legal construction textbooks. What I'm going to cover this, or try and cover this morning, is an outline of how to identify whether you are working with a hybrid contract, and if so, the things that you can do at the drafting stage to avoid issues arising as a result. Next slide, please, Leah. So as most of you will be aware, if a contract falls within the scope of the Construction Act, the parties will have a statutory right to adjudicate at any time, no matter what the dispute resolution method is in the contract, and the payment provisions in the contract must comply with the requirements of the Construction Act. Therefore, it's really important to be as certain as possible at the outset that your contract, if it's going to fall within the scope of the Act, is compliant. Now, the full details of the scope of the Act are set out in sections 104 and 105 of the Construction Act, and they're very long and detailed provisions which set out many different types of construction works and related consultancy services that will be included. It's too detailed to really cover in the time available in this session this morning. But in summary, you first look at section 104 of the Act, which defines construction contract, and anything that falls within the definition of construction contract will fall within the scope of the Act. And then from construction contract, you look at the definition of construction operations in section 105 of the Act, which sets out that detailed provision about the sort of works that will and won't be included. Now, the definition of construction operations in section 105 creates a two-limb approach to identifying whether your contract comes within scope. First of all, you have to look at whether your contract and the works will be construction operations within the meaning of the Act. And then you have to look to see whether, notwithstanding the fact that they will be construction operations, they're expressly excluded, whether it be because they relate to a certain type of project or various other exclusions in that clause. Next slide, please, Leah. So moving from that sort of two-limb approach to construction operations, what are we talking about when we talk about hybrid contracts? Hybrid contracts arise where your contract relates to works that will both be within the scope of the Act and outside the scope of the Act. And this is also has basis in the statute, section 1045, which is on the screen on the slide, states that where an agreement relates to construction operations and other matters, and that's construction operations within the definition of the Act, this part, that's that part of the Construction Act, will apply only insofar as it relates to construction operations. So if the situation where you have in and out scope works primarily arises in two sort of different scenarios, and these are the ones we typically see the most. So the first is where the contract relates to construction operations within the scope of the Act, but some of the parts of the works within the scope of the contract don't fall within that definition of construction operations. So a good example of this is where you've got you've got a contract for the fabrication, delivery, and commissioning of pieces of equipment to be installed in an offshore project, for example, an offshore substation. The definition of construction operations only includes construction of structures forming part of the land. So offshore works will not be included. But if part of those offshore works are going to be fabricated and delivered on the land, so for example, to a port where they're going to be installed onto a substation, which is then taken offshore, that fabrication part will fall within the scope of the Act. So there's a situation where you've got works under the contract which are both in scope and out scope. The other common example is where you have a contract for example, an EPC contract for a type of construction operation that is expressly carved out from the Act. But some of the works that need to be done as part of that contract will not be caught by the carve out. So for example, an EPC contract for the design and construction of a electricity or energy generating plant, the overall works will generally be expressly excluded because the primary activity is going to be power generation. But ancillary enabling and design works, or works relating not relating to the power generation side of the project, so for example, electrical wiring of the site office, will likely not be caught by the carve out and therefore will be included within the scope of the Act. Navigating these distinctions has become increasingly difficult over the years. There were some early cases that tried to look at the overall scope of the contract and try to look at it as sort of a holistic way, but those have generally been reversed or have been superseded by later decisions, which, because of the attitude of the court, who really don't like, generally, the courts don't like these carve-outs and exceptions in the way that the construction operations is defined in the Act. And so over the years, they've done their best to try and narrow and erode the scope of those exceptions and the ways that parties try to get out of the Act. And what that has meant is that we have quite an uncertain and nuanced position, which really makes it a very difficult question for parties at a pre-contract stage to work out the extent to which any of the parts of their contract or works are going to fall within the Act. Next slide, please, Leah. So what does this mean in practice? Well, as mentioned earlier, if your contract or part of it falls within the Construction Act, then the parties will have a right to adjudicate at any time. If you didn't realize at the contracting stage when you were drafting the contract that your part of your contract might fall within the Construction Act, and you haven't included adjudication clauses into your contract, or you haven't checked that the clauses you have included are compliant, then if a dispute arises in relation to construction operations, the Act will step in and the scheme for construction contracts will be implied wholesale into the Act. Now, that can be, when you're already in dispute, that can be really inconvenient and can be an unnecessary issue for the parties to have to deal with. They might not like exactly the scheme rules, or there might not be, they might not have thought about an appropriate nominating body for the adjudicator. The other issue that can arise relates to payment provisions. If your contract doesn't comply with the minimum payment provision requirements of the Act, and it includes some works that are within the scope, then the Act will step in to imply provisions, the relevant provisions from the scheme, to plug the gaps where the contract is deficient. What this can actually mean in practice is that you end up with different payment provisions applying to different parts of the works. I mentioned C. Spencer case on the slide there. I'm not going to go into detail about that case, but that is a case that were related to payment provisions. Things worked out. There wasn't an issue in the end, although it led to a lot of dispute and went right up to the Court of Appeal. The payment provisions in that contract were Act compliant. And so actually that the court found that because they were compliant, you didn't need to differentiate in payment applications between construction and non-construction operations. But if that contract hadn't been compliant, then the outcome could have been very different, and it could have caused all sorts of problems as to the validity of payment applications and how the parties needed to deal with them. So what are our key aims in dealing with hybrid construction contracts? Well, the problem, as I've highlighted, and is highlighted by the amount of case law on this subject over the years, is that dealing with hybrid contracts and the issues they raise causes lots of uncertainty, and uncertainty in your contract is always going to foster dispute. And dispute, despite being a dispute lawyer, we will all admit dispute leads to unnecessary costs for the parties, especially if it's mid-project, and is also a distraction. So the key aim is to try and make sure that you have drafted your contract where you think it might be a hybrid contract to avoid those uncertainties and avoid issues arising. And the two ways of doing that relate to the two areas of the implications of the Construction Act. So for adjudication, we would recommend either adopting adjudication for any dispute arising under the contract, or in circumstances where that's not desirable, and that's often the case, that the parties have had a bad experience of adjudication in the past and therefore want to avoid it. You can include a hybrid adjudication clause, which only gives a right to the parties to adjudicate disputes relating to works that will fall within the scope of the Act. Now, it's important that that definition is, and that clause is drafted appropriately, because it's no good including a hybrid adjudication clause if your definition of what will be included can still fall foul of the Act. And so we usually recommend drafting a clause of that kind by reference to the Act. That also allows for any change in the legal position during the conduct of the project. In respect of payment clauses, if it's going to be a hybrid contract, there's unlikely to be a situation where the parties want to have two different payment regimes under the contract. Therefore, it is best to check that your payment clauses will be compliant with the Act. And if you're using any of the the common UK standard form contracts, NEC, FIDIC, JCT, ICME, then it's likely that the payment clauses, as long as not too much harm has been done to them by bespoke drafting, the parties should comply with the Construction Act, and therefore you shouldn't have any issues there. So this all raises the question of whether it needs reform. The Act was drafted when the provisions in it were seen as a punishment for an industry that wasn't working and operating properly, and therefore certain industries that are included in the carve-out successfully lobbied the government to be excluded from the scope of the Act on the basis that they weren't regular offenders of the problems the Act was going to try and address. But nowadays, I know there are some people that still have reservations about adjudication, but both adjudication and the Act payment requirements are seen as something that is generally positive if handled in the correct way. And so there might be argument these days really for reforming and changing the definition to try and avoid the uncertainty and complications. And that's certainly the view of the courts, including in particular Lord Justice Coulson, who has a particular issue with this. So hopefully that's been a helpful overview. As I say, it's important to get these clauses right. We draft both hybrid clauses and check payment provisions all the time. It's something we regularly do. If you want to avoid problems with hybrid contracts, it's best to try and make sure that you've got that checked at the contract stage. Thank you for listening, and I'll now hand over to Dan Miles of Aquila Forensics for the next session.
Thank you very much. So for my session, I'd like to try and talk about disruption. And we've titled it Who Pays When Works Are Disrupted, but actually we're trying to run through 7 points to consider, either if you are wanting to bring a claim for disruption, or if we're now in a situation where we're trying to defend a claim against us for disruption. Now, the interesting thing about disruption and why it raises so many papers and so much discussion is the fact it's one of the harder claims to actually quantify, and it's generally a harder claim to be successful with when you use it in adjudication, arbitration, or some other form of resolution. And I think to begin with, trying to actually explain why disruption is so difficult. And to use an analogy of weather, if it rains, it's very easy for us now to use a rain gauge to measure the amount of rain that's fallen and have a very, very clear quantified number when it comes into the amount of rain. If we consider disruption instead like fog, we all know it's foggy. We all know when it's been disrupted. We all know that our productivity on site is not what it should be, but trying to quantify the amount of fog that is present is much harder. And therefore, if we think back to our example of the rain, if you think of that in terms of a variation, very easy to quantify and very easy to present, disruption becomes slightly more amorphous. We know it's there, we know it's happened, but trying to actually raise a successful claim and to actually demonstrate the amount of fog or the amount of disruption becomes much harder. So on the first slide, what we're going to be looking at and considering is the fact that, again, why is it so difficult? When we discuss prolongation and extension of time and the costs that flow from that extension of time, it is fairly simple to classify our site prelims, our time-related costs, and to demonstrate we've been on site longer, and therefore we've now incurred additional costs for this. And there's a tendency, even on some very high value claims, for people to actually turn around and say, well, in exactly the same way that we've got an extension of time, we must then surely also have a claim in terms of our direct costs, our site personnel, the site labor, and the site equipment. But the problem is, whereas our time-related costs are a fixed cost that have been driven by the passage of time, our site-based costs, our labor, are not just affected by time, although that they may be, but they're also impacted by the amount of work being produced and their productivity. And therefore, simply taking a prolongation style assessment of we have 50 people on site, we have an extension of time for 2 weeks, and therefore we're going to times 50 people by 2 weeks, doesn't get over the hurdle of the fact that actually you recover your costs of your direct costs through your bill of quantities or through your lump sum, and that's a function of their productivity. If it takes one person 2.5 hours to weld a pipe, you get paid for that pipe weld when they've completed it. If we have originally a plan for 10 people on site welding pipes, then we'll probably end up producing 10 times the quantity of one person. But with disruption, we may halve the number of people and therefore halve our output, but not make any loss because we're still achieving an output of 2.5 hours per weld. So we have to be considering productivity and not just a delay to our time. So on our next slide, what we then have to consider is that we first become aware of disruption is because if we've allowed 2.5 hours for a weld in our tender, and on site it's taken us 3 hours or 4 hours to do a weld, we know that we are now losing money and we know that we've been less productive and therefore potentially have a disruption claim. But just because we wrote something in our tender doesn't mean that we could ever have achieved it. Just because example from this picture here, just because the sales brochure for this beach makes it look absolutely stunning and paradise, doesn't always guarantee that when we get there isn't a construction site behind us and there's now actually a lot of pollution on our beach. So simply comparing the productivity that you've achieved against the productivity that you planned in your tender doesn't guarantee you have a disruption claim, because you have to be able to prove that you would have always been able to achieve what was allowed in your tender. And for that, what we want to be considering is techniques like, for example, a measure of mile or industry benchmarks, or something that allows us to demonstrate what we could have achieved as a baseline to compare the actual productivity that happens. Next slide, please. And As part of that, we then need to consider the fact that disruption can often happen in very small places. And when we first look at our outputs, it's very easy to take a global approach. We intended to spend 10 million pounds or 10 million euros to do this body of work. We've now spent 15 million. Our claim is the difference between the two. We want a 5 million claim. But if the item of disruption that we are claiming was out of sequence working for a defined element of the work. So if we're now claiming late design and out of sequence working in relation to the laying of a pipe, then we can't necessarily take all of our losses that now may include civils works, it might include above ground works and other works that are totally unrelated to the item of disruption. And therefore, to be successful in demonstrating that our loss results from the item that we're claiming, we need to deglobalize our claim. We have to start looking down to how we can break this claim down. And therefore, we need to be considering these elements and these issues when we set up our project and when we set up our systems for how we're going to record labor on site, how we're going to record our cost, and how we're going to record our productivity. Because the more we can deglobalize, the easier it is to demonstrate our loss and to be successful with a disruption claim. Next slide, please. So this now goes to the next point. On the globalized aim side, it's very easy to demonstrate we've had a loss. It may be very easy to demonstrate the fact that we've had a loss of productivity. But we now need to demonstrate that our loss of productivity does relate back to the employer and is somebody else's fault and not our own fault. There's an excellent paper by Professor Ibbs, which is available online. You can Google it very easily, where there's a mind map produced showing all the different elements that can impact the productivity on site. This will include fatigue, it may include training and skills, learning curves, seasonal weather fluctuations. All of these elements can impact our productivity, and majority of these have no link to a claim and no grounds to actually bring a claim against the employer. And therefore, we have to consider how we can demonstrate that an element of disruption does result from our late instructions. It does result from out of sequence working that wasn't our fault, due to access problems, due to weather under the NEC, which is now beyond the 1 in 10 year event. Whatever the basis of our claim, we have to be able to link that now back to the employer's liability. And again, this becomes easier the more that we can deglobalize our assessments, and it becomes easier the more that we're able to actually use a benchmark within our project. I realize I'm running slightly behind time, so next slide, please. So having established that we have been disrupted and we do have a disruption claim, we now need to start valuing that claim. It's very easy to pick up our day work schedule and to use that, but the problem is our day work schedule and items in our bill of quantities is not cost. Under most standard forms of contract, a disruption claim will need to be based upon your actual loss and the actual cost you've incurred. So it's key at this element to consider how you're going to demonstrate your costs and whether or not you're prepared to actually show your costs, but whilst being mindful that trying to limit your assessment to the bill of quantities may not be compliant with the contract and may give you problems on the recovery. Next slide, please. And having earlier on talked about how we want to deglobalize, we want to isolate our disruption, it's important though now, this starts kind of the antipathy of that, it's important to consider how an element of disruption to one part of the site will often ripple and impact wider elements of the site. But we should still be starting with the isolated elements and trying to deglobalize, and then we can show and demonstrate the ripple. If we start at a globalized claim, it becomes very difficult to demonstrate and explain the relationship between the disruption and the original cause. And therefore, what we tend to do is we tend to try and start with an isolated analysis and then consider how it ripples into the rest of the site and the rest of the works. Next slide, please. Now, again, when we produce our disruption analysis, you'll often end up with a productivity curve and a set of productivity lines. These may show periods of underproductivity and then periods of overproductivity. And therefore, the question is, should you give credit for the overproductivity within disruption claims to net off against the underproductivity? And the answer is it depends on the data set, it depends on the case, and it depends on the analysis. if we have excellent data set and we can actually link our cost and our earned value or our productivity, and we have high confidence in our data, you generally wouldn't give credit for periods of overproductivity. If, however, we're concerned with our data set and we now have periods where we think that the measurement of work executed falls later than the periods of our cost, and we don't think that productivity line lines up correctly, then in that instance, we may have to consider both the over and under productivity to ensure that we smooth out any errors inherent within our data set. But it's a question that needs to be considered when doing disruption analysis. Now, in terms of disruption, it's so important to understand that what we can do with our data is driven by the quality of the data. And it's very rare that all 7 points we just covered, you're actually able to cover all of those and be able to have an excellent data that allows you to actually fully present all of those items. And therefore, so much is a case that what we can and can't do with disruption analysis is driven by the quality of the data and what we have available to us. But these things also need to be considered when setting the project up to ensure that if you are disrupted, you can bring a robust claim, demonstrate that it's actually the liability of somebody else, and be successful in your quantification. So thank you very much. That was my 7 points on disruption, and I'm now handing over to Barry next. Thank you.
Thanks very much, Dan. So in the final presentation today, I'm going to look at how not to carry out a construction project. So I'll try and keep it as light-hearted as I can. As we've seen today, disputes on construction projects do arise. And when they do occur, research has shown they take about 9.8 months to resolve. So that adversely impacts on management time and on internal resources. And we see these problems as construction lawyers all the time. So the object of the next few minutes is for us to share some points with you on how to prevent some of these issues arising. And I'm going to discuss with you today a live project, and I'll frame our discussion by reference to that job. So by way of background, the project is currently ongoing. It's a job in the UK. The project is currently about 45% over budget. It's due to complete 5 years later than planned. The project cost has cost the public millions of pounds. Delays and cost overruns have resulted in a parliamentary inquiry. And the report from the parliamentary inquiry frames some of the points that I'll be discussing during this presentation. So what is this project that's resulted in all this drama? So is it HS2? Is it Hinkley Point, the new power station? No, it is, of course, the project for the construction of the new EastEnders set. So on the next slide, you'll see the set that I'm talking about. We've shown on this slide the proposed setup. It's at Elstree Studios. Albert Square, it was a set that was built in 1984. 30 years later, the BBC has decided to replace the set under a project called E20. In 2013, the BBC has said that the project would cost £60 million and complete in August 2018. It's now cost the licence fee payer £87 million, and the job's due to finish 5 years late. And the report from the parliamentary inquiry has highlighted a number of issues, and they're of relevance to anyone that will be contemplating carrying out construction works. So everything that I discuss with you today is in the public knowledge. So there are three main points, as you'll see on the next slide, 3 or 4 main points I just wanted to run through with you that were highlighted in the report. The first related to design risks, the second procurement issues, third contract negotiations, and the fourth contract administration. So I will start on the next slide by a brief discussion about some design risks. The first point that the inquiry highlighted was that the project team that was carrying out the job didn't have the necessary construction skills, and setting up the project from the start with a team that didn't have the necessary skills had a knock-on effect in the later stages of the project. So from the BBC's perspective, the report said there was insufficient construction knowledge, in particular, to manage the design, the procurement, and the construction activities. And this resulted in the BBC, for example, having to commission internal and external reviews of design problems. having to look at design development and change processes. The report said that the BBC hadn't introduced those reports early enough. It took supposedly a year after the business case had been approved before design change process was agreed and implemented. That resulted in about £440,000 worth of design changes in the system. So a huge backlog of design changes that then had to be authorized once the system was set up. And these problems were exacerbated by the teams failing to work together. So in terms of why variations arise, I've set out some points on the next slide, and really it occurs that they primarily arise due to poor planning, such as where the procurement process doesn't allow enough time up front for stakeholder engagement or design development. There may, for example, be an ambiguous specification. So in that case, a contractor may look on that ambiguous specification as full of tender risks and challenges. And there may be a lack of clarity about activities and expenses that need to be incurred. In an ideal world, design problems are best managed in a pre-construction planning phase. That's the time when owners, designers, and contractors can align and manage risks more closely. That's not always possible, but the issues that were highlighted from the report show the importance of investing in the early stages of the project to make sure that the job is set up with the right team in place from the start. The next of the 4 issues that I just wanted to touch on is procurement. And this was another point that came through from the report. So from the BBC's perspective, they were criticised by the investigation for an incoherent procurement approach, which was said to have cost the project £2.3 million. Now, by procurement, we mean the process by which resources are marshalled and contracts agreed for implementing the project. In 2016, the BBC carried out a single stage procurement for the front lot. Unfortunately, that procurement exercise was unsuccessful due to a limited market interest. And so the BBC decided to change that process to a 2-stage procurement using its own framework agreement. 2-stage procurement allows tenders to be based on an initial scope that then remains to be more fully defined at a later stage. And once the scope is more fully defined and developed, the tenderer can put forward a more detailed scope, and that scope is then confirmed and is the subject of the construction contract that's entered into. On our next slide, I set out some of the advantages and disadvantages of the 2-stage tendering. So one of the advantages is the early involvement of the contractor that can help with identifying the scope to be defined and that can tailor the scope to the benefits of the job. But there's also a number of disadvantages as well, such as no guarantee of price certainty, or the risk that the second round of negotiations with the preferred contractor may result in difficult and protracted discussions. In the BBC's case, the second procurement ultimately led to a contractor being appointed, but the contract sum was still £9.5 million more than budgeted. And the second procurement delayed the job by about 6 months. In terms of some of the action points, these are set out on the next slide. And I think the important point is look to see what information is available, choose the best procurement approach that is centered around the most available information. And remember that time costs money. Be very cautious about aborting one procurement approach and implementing another. The third point I wanted to touch on this morning is in relation to contract negotiations. The contract negotiations with the preferred contractor on project T20 took about 11 months, so that's 6 months longer than planned. And lengthy discussions were the result of more expensive offers being returned by the contractor. And there was also an issue about design development, primarily about the bricks to be used on the set, because the BBC were keen to create the same look and feel that was on the existing set so that viewers wouldn't know the differences. And commercially, not entering into a construction contract early enough can mean that costs and time issues are not locked in. And from a legal perspective, it can create uncertainty about the terms that have been agreed. On our next slide, I refer to the case of Balfour Beatty and Vanelli. That's a very recent case where there was a dispute between a main contractor and a subcontractor concerning piling works for a subsea cable manufacturing facility in Newcastle. Vanelli tendered for the contract. Some works were carried out by Vanelli on the basis of its quotation and letter of intent prior to the main contract being entered into. After the job completed, defects arose and Balfour Beatty had to rectify those defects. And the issue before the court was whether the works had been carried out by Vanelli under the letter of intent, under which Vanelli had substantially limited their liability, or whether they were completed under the subcontract. Now, the judge found in favour of Balfour Beatty and held that the subcontract had governed all of the works, including those carried out prior to execution. And while Balfour Beatty and Vanelli is not perhaps surprising on the facts, it's a helpful reminder that where works commence under a letter of intent before a contract is finalised, the courts are likely to find that an interim contract is superseded by a formal contract that may be entered into later. The final issue that I just wanted to touch on very briefly is contract administration. And it's worth reminding ourselves that even when there's been sufficient preparation for a project, when there's been the right procurement choice, when the contract has been concluded, that it's still important to ensure that the appropriate contract administration is applied to the project. And surveys have indicated that most construction disputes still arise during the contract administration stage. So the last Arcadis construction dispute survey highlighted that a failure to make interim awards and extension of time and compensation events remained the top ranked common cause of disputes in the UK construction industry. So in that survey, 75% of respondents said that the contract administrator's conduct was always or very often at the heart of how a dispute had crystallised. And it was said that a lack of understanding on the procedural aspects of a contract generally underpinned the reasons for a dispute. So in terms of action points on that point, I think it would be appropriate to, as set out on the next slide, familiarise yourself with the contract, don't put it in a drawer, ensure that care is taken, that contracts are properly administered according to the correct terms, make sure that awards of time or money are certified if due, and ensure that the appropriate notices are in place when they need to be. So in conclusion, how best to manage risks on construction projects? In the final slide, I've set out some points that need to be considered. So finally, it's best to identify with stakeholders to consider what potential risks could go wrong with a project, assess those risks by reference to a sliding scale, identify the impact those risks could have if they were to occur and prioritise the largest risks, mitigate those risks by developing plans to implement stages to mitigate risks even when they occur, and protocols as to what should happen if risks arise, and monitor on a regular basis the risks, scan the horizon to ensure that any risks will be minimised. Greater preparation is definitely worth the effort. At best, it will help turn a project into a success. As a minimum, it will help prevent a project from becoming a drama. And on that note, I will now hand back to Rebecca.
Thank you very much, Barry. Sage advice indeed. And also, just to let everybody on the webinar today know, we frequently actually offer bespoke training sessions for clients for their commercial and site teams, which are based on the contract. So it's sort of, you know, a workshop at the outset of projects so that everybody is familiar with the contract and how to operate it to best advantage, what to watch out for, and obviously to encourage rigor throughout the project in terms of issuing notices on time, etc. It seems quite elementary, but we find that most people appreciate the training, and we do tailor it to the contract in question. I think we're going to have time for a couple of questions. We've got a few coming in. For those who are unable to stay on for the short Q&A, I'd just like to thank you very much for attending today. We will be sending around an email with the slides and some other material, and also the feedback form that I mentioned, because obviously we have a number of these in planning, and we'd like to tailor them to content that's most relevant. So thank you very much to everyone for attending today. And I am going to now just pose a couple of questions. And who should I choose first? I think, well, actually, this is one that anyone can pick up, I guess, because I know that everyone on the panel has been involved in a lot of adjudications recently. But the question is, since the pandemic, have you seen an increase or decrease in adjudications? And what have those disputes been generally concerning? So I'll put that. Ryland, you've possibly had the most recent adjudication, if you want to take that one.
Yep, I will do.
Farley.
Thanks for volunteering me. Yeah, I think the starting point, actually, if we look at the Adjudication Society report from 1920, which not the year 1920, from the year for 2019 to 2020, it actually stopped reporting just before the pandemic. So we don't have any official figures for this. But for that year, they reported 1,945 adjudications had been passed to nominating bodies. I suspect the true figure is higher than that. But what was interesting is that was an increase of only 2% over the previous year. In my experience since the pandemic, I've seen an uptick in adjudications. I suspect we will probably see figures that will show an increase in the number of adjudications. And the simple fact is that obviously the pandemic has caused a lot of problems. Clearly there were problems with supply of labour, supply chains themselves, access to site, and general movement of people. And then you had, of course, changes to the law in relation to the coronavirus regulations and the act that followed that. So in terms of numbers, I certainly think we'll see an increase since that report, and when the new report comes out, that will obviously confirm that. In terms of subject matter, I have seen a trend toward more true value adjudications. So the smash and grab is still alive and well in terms of people trying to get money on the back of a technicality, but the arguments are becoming more complex, and parties seem to now be opting more for true value disputes, which I think is a positive step forward, because it means the parties are going to get the benefit of a proper analysis of the sums due to the parties. And the other thing, of course, we're seeing is disputes about the coronavirus itself, and whether the lockdown was a force majeure event, whether it represents a relevant event or a relevant matter under the JCT contracts, and under other forms of contract, questions about whether you get time only or whether you get time and money. And I think a lot of those disputes will now grow into litigation, so we'll start to see judgments come through, but it's not stopping here. I can only see it increasing, because a lot of those issues have actually been parked by parties, and the early sort of appetite for settlement seems to have dwindled a little bit as cash flow gets tighter and parties have no option but to take their disputes forward.
Thank you, Ryland. I agree. I sort of feel that we're in somewhat of a phony war situation. But certainly, yeah, I agree. I've certainly seen a lot of disputes over whether COVID constitutes, a relevant event or, a compensation event in a number of contracts. So if I look at the other questions, actually, this is a personal favorite. Well, this is a favorite topic of mine. It's really a question for you, Alex, which is whether or not you think that there would be benefit in reforming the Construction Act and doing away with the exceptions, I guess, to construction operations. I mean, my view on the subject.
Yeah,
I think it makes contracts needlessly complicated, but yeah, over to you.
I think that's right. I think, as I said during my session, there was the reason that the definition of construction operations is so just drafted in such a complicated way is because there was, as I understand it, there was the definition of construction operations, and then various industries lobbied to get themselves carved out. I think that we have now seen, and you have to remember at that time, adjudication was a completely new type of dispute resolution, and we now have an established practice of how to run adjudications, and if it's run properly, it's not something to be feared or to be overly worried about. I think there are certain large projects that people will say it's not really suited for, and those are the sort of projects that might be caught within the exceptions and carve-outs. But really, I think in the interests of simplification and the benefits that you can get on a project from getting a quick and easy decision about something, then there is definitely an argument for reforming it to make the definition much more straightforward and much more inclusive. And to compare it about something, I mean, to sort of allay people's fears, we frequently include expert determination clauses in very highly technical and complicated and large projects, and an expert determination process is often as short form and as quick a process as an adjudication. So I think that the idea that it's not suited to these more complicated projects is probably, given the sophisticated and experienced practitioners that are out there to be able to run adjudications for you. I think personally, I see no reason not to widen the scope of and simplify the definition in the Act. And that's something, as I said, seems to be supported by most of the judiciary. You would, in this country, you would think that traditionally judges like to have things interpreted so that they can get to decide on them rather than some alternative forum. There's sort of a competition between the High Court and arbitration, etc., whatever it might be. But certainly on this, the TCC judges generally seem to be in favour of some sort of, and this is based on comments from Coulson and others, of reform. And I think I would agree with that, really. And I think there's a lot of benefits from simplifying the process and actually from bringing projects within scope that could benefit from the benefits of the Construction Act, really.
Thanks, Alex. Sorry, lost my video feed there. As Coulson says, let's roll out the benefits of adjudication to everyone. Obviously, that could be a controversial statement depending on your personal experience of adjudication. I've certainly had a mixed bag myself. Dan, this is a question for you. You mentioned, obviously, the 7 key points to consider. Which, in your view, is the most important point of those 7?
I think it's one of these ones whereby it's just making sure you've demonstrated a loss of productivity. It's so easy once you know you have a loss just to simply demonstrate you have an extension of time and you've been there longer, but it's actually recognizing a disruption based analysis has to consider productivity and proving a loss, no matter which method you use to get to that point. If you start from there, then there's something to work with, really.
Thank you. I think we've got time for probably just one more question. We will be almost sort of 10 minutes over time. And the other questions that, thank you very much for sending them through via the Q&A. We'll pick up on those and actually respond to them personally. Happily, we do have the name of I think there's a few left over. So finally, I guess just in the interests of being fair and even-handed, a question for Barry. You spoke about variations. What changes result in variations and who pays?
Good question. So I think it really comes down to, what's in the contract, but usually it would be where there's been a change of scope, for example, where works maybe are being carried out in a different manner to what was originally anticipated. Maybe works are suspended. Perhaps works are omitted where there's a omission clause in a contract. So I think it very much depends on where the contractor is asked to do something that wasn't originally planned for, wasn't originally in the contract, and who pays will generally be determined by the contract terms. So if the person who asked the question provides a bit more information about the type of contract that was used, we may be able to explain a bit more about what the variation mechanism is under that job.
Of course. Thanks, Barry. Well, I think in view of time, we should probably wrap up because we've gone a bit over, but just wanted to say a very big thank you also to Dan for joining us today from Aquila Forensics. That was really interesting presentation. I really enjoyed that. I think I might have mentioned to you before that disruption is, well, it's a pretty thorny issue, very difficult to prove. And so I'm always interested to hear more on that subject. We could all benefit from your tips there in terms of sort of establishing a claim and learning a bit more about it. So thank you once again to all the other presenters and to everyone who attended today. And as I said, we'll be sending out some emails, and I will ensure that we follow up on any questions that weren't answered today. Okay, thank you, everybody. Have a good day. The sun is shining, so enjoy. Bye.